Hello, this is Rick Fee of the Kettering Hospital System. I'm introducing our speaker today. Stop moving your mouth. I wasn't moving my mouth. You were. Just stop it. The speaker today, not a very good speaker, but really the only one we have, Alan Gassman. He's going to discuss creditor protection. Don't put them all to sleep like last time, okay? All right, I'll do my best. Welcome to this installment of the Kettering Health Foundation series entitled Today's Talk, Putting Asset Protection into the Estate Plan. We're going to spend about half an hour. It's actually going to seem longer. And then I'm going to make a special offer to you to get a free estate tax planning software package if you sign up for this amazing program. So thank you very much for joining us, and I hope that we are giving you information that you can use. We are gearing up to a May 18 full-day event in Kettering, Ohio, near Dayton, right near the Wright Brothers Museum. We're going to have Clary Red, Jerry Hash, Jonathan Blottmacher, and me to talk about planning techniques, estate planning, and in the afternoon, charitable planning. Right near the Wright Brothers Museum, right near the National Museum of the U.S. Air Force. It's going to be a great event. At least for the speakers, it'll be a great event. Okay, so a lot of what I'm talking about today is seen in much more detail on our YouTube channel on asset protection. So if you don't get enough today, let me know. You can find it on the YouTube channel. In addition, if you sign up for the Kettering conference, for this conference, the Kettering conference, then I will send you a complimentary copy of our book, What CPAs and Other Advisors Need to Know About Bankruptcy, and also Gassman and Markham on Florida and federal asset protection law. I've got so many of these, I don't have room for them, so please sign up so you can get these free books. Now, I have a table of contents here, and I have 28 minutes. So that gives me about 12 seconds per slide of the 295 plus slides that I have here. And I'll also be answering questions. So good luck to you if you are an attendee. Many clients will say to you as an estate planner that they have insurance, so they don't have to worry about creditor protection. Some of them even have $5 million of liability insurance. Well, guess what? $5 million no longer even puts a big dent in what can happen with jury trials. Here you had a 13-year-old with a $32 million verdict. Here you had one pretzel caused a $30 million verdict, actually only $29.5 million. That's one pretzel. Can you imagine if it had been two pretzels? Then third, here's a car accident, one person hurt, $730 million. So these things go on and on. Look at this one. Fluorescent light poisoning, $185 million. So if you want to have enough insurance, just get $185 million worth of liability insurance and you'll be fine. So let's remember, it was not raining when Noah built the ark. There is something in every state called the voidable transfer statute or the fraudulent transfer statute. And what it says is, don't wait until it's too late. Get your planning done in advance. So when the client comes to you for estate planning, one of the things you want to think about is where it goes when they die. One of the things you want to think about is how can we help avoid taxes? But one of the things that you want to think about and that you need to pay attention to during the conference is the creditor protection aspects. Because, the client comes in and They come in and you do a revocable trust for them so that they can avoid probate and guardianship. And they think that that avoids creditors. And it doesn't. And in fact, it may even hurt with creditors. In Florida, we have beautiful statutes that say that the life insurance that I own on my own life can be creditor proof. An annuity where I'm the annuitant can be creditor proof if owned by a person. A revocable trust is not a person. So for many of us, we have revocable trust estate plans, but we need to not fund the trust. In Florida, Delaware, and other tenancy by the entireties of states, including Wyoming, many of us form separate revocable trusts for each spouse, but then we place the assets into a tenancy by the entireties account or a tenancy by the entireties asset. And the reason for that is now in my illustration here, if spouse one gets sued for malpractice, the creditors in Florida can't take tenancy by the entireties assets. The creditors of husband can't take the assets owned by wife or by wife's revocable trust. So we really want to think about where are you putting the assets and where should you put the assets, what is exposed to creditors and what is not. So we could have a second tier here. I've got a husband with a revocable trust that nothing will go into until he dies. If he has permanent life insurance in Florida, I'll have him own the policy and let it be payable to his revocable trust, or I will put the policy in an irrevocable life insurance trust, also known as an ILIT. Now, wife may be at less risk. Maybe husband's a neurosurgeon, wife is a stockbroker, or wife is a soccer coach. Do we want to go ahead and put assets under the wife's revocable trust? If she dies first, we're going to get a step up in basis, so there will be less capital gains tax, and her trust can become irrevocable on her death. That's Latin for irrevocable. And then husband could be a beneficiary of her trust for health, education, maintenance, and support. He could even be the trustee, and his creditors will not be able to reach that trust. And if and when he remarries, as if he could find someone else who likes him, his new spouse would not be able to take assets out of that trust. So this may be a very sound creditor protection plan. But what happens if somebody sues the soccer coach? She's in a car accident. Well, how about if we put the most of her assets into a family limited partnership or an LLC, owned 1% by the two of them jointly, 96% by her irrevocable trust, and 3% by an irrevocable trust for their lovely children. Now, if you get a judgment against that wife, you can reach into her revocable trust, but you will have the benefit of the charging order rules. And the charging order rules say, in the states that have them, that if you get a judgment against me and I own, for example, 97% of an LLC, my daughter owns the other 3%, your sole remedy with respect to that LLC is to receive what the court will call a charging order. It has nothing to do with making seltzer water. That's a charging machine. This is a charging order. So with a charging order, I have to make a distribution to the creditor if and when there is a distribution from the LLC, but not until then. So it puts me at a standoff, at a deadlock with that plaintiff who gets a judgment against me. I can't take anything out of the LLC, but they can't either. And typically they will settle before trial for policy limits, if you have decent policy limits, if the only thing they can hope for is a charging order. Now, why did we give 3% to an irrevocable trust for the children? The reason is not because we like the children. In fact, many times clients confide in me, they don't like their children at all. But if we gave 3% to a child or an aunt or an uncle or a best friend, then the FLP or the LLC would have to file a partnership income tax return every year, which can cost significant dollars. On the other hand, an irrevocable trust for your children that you have the right to replace assets of in exchange for assets of equal value can be disregarded for income tax purposes so that the trust does not have to file an income tax return, and either does the married couple. Now, the IRS doesn't always agree with this. If you don't live in a community property state, then the directions to the partnership tax form 1065 say that you are supposed to file a partnership return if you have a disregarded entity, if you have both spouses as members. But I and others believe that this is not the case. Believe it or not, the IRS is not always right in their instructions. The Bloomberg B&A portfolio on disregarded entities says it can be disregarded. And there is a revenue procedure which says that if you should have filed a partnership return, but you didn't, but all the income and deductions went on all the right tax returns, then there is no penalty or interest as long as the partnership return is timely filed. Okay, now what is on the far right of this chart? A spousal limited access trust, also known as a SLAT. So husband transfers $1 million to wife as trustee of a spousal limited access trust. Wife can receive what wife needs for health, education, maintenance, and support, and can direct the assets as wife sees fit on death, even to go back and benefit husband. Husband's creditors can't reach the trust because he's not a beneficiary. Wife's creditors can't reach the trust because she's not the settlor, and she's limited to receiving what she needs for health, education, maintenance, and support. The trust is out of husband's estate and wife's estate for estate tax purposes. So not only is this a really good estate tax planning tool, but it is also a very good creditor protection tool. You could put the trust in an asset protection jurisdiction, such as Alaska, Delaware, South Dakota, or Nevada, and provide that if the husband's net worth ever goes down way below what was expected, and trust protectors add him as a beneficiary, that maybe he can benefit from that trust. And that might work from an estate tax standpoint. It may work from a creditor protection standpoint. There's more information in the books that you can buy or get for free if you sign up for the Kettering Institute. Okay, now let's talk about a person who is single. One digit. What can this person do to protect their assets? Well, maybe all their assets belong to their ex-spouse, so there's nothing to protect yet, but maybe there will be. So I've got a non-married invididal. We'll fix the spelling on that later, but right now it's a non-married invididal. And they own a homestead in Florida, Michigan, Texas, or one of the other states where homestead is protected. In Florida, it's protected for unlimited value It could be $100 billion home, up to half an acre within the city limits, up to 160 acres outside the city limits, and our Florida constitutional protection of homestead trumps, no pun intended, trumps the fraudulent transfer statute. So if you get a judgment against you, like O.J. Simpson did, like Bowie Kuhn did, and you move to Florida and put clean money into a brand new homestead or a used homestead and move in, then Florida courts will not allow that judgment to be enforced unless the judgment is from a United States agency, such as the IRS, the FTC, or the SEC. So a lot of folks do move to Florida when times get tough, or they may tell their creditors, you know what? If this doesn't go well in a couple of years after the jury trial, you may just see me move to Florida. You want to settle this or not? Now, speaking of that type of conversation, if you engage in that type of conversation, you may find that the plaintiff will get a judge to enforce an injunction saying you can't move your assets because you threatened to move them to Florida, where that nasty Disney World is. So they may enjoin that. So you don't actually say that to the creditor. What you say to the creditor is, you know, I have choices. I have choices. Then, besides the, oh, and by the way, if you move into a homestead and creditors force you into bankruptcy, and your purchase of the homestead was to avoid the creditors, then if that happened within 10 years of filing the bankruptcy, the court can set aside the transfer. But if you have at least 12 creditors, it would take 3 of them to force you into bankruptcy. So we do have clients that have 1 or 2 creditors who are quite angry with them, and then 10 or 11 creditors who really don't care but are owed money. So that there's no 3 creditors to force the client into bankruptcy and divest them of the homestead. So then on the left-hand side, IRA is creditor proof, 401k is creditor proof, annuity contract creditor proof, permanent life insurance policy creditor proof, money put into a wage account and kept there up to 180 days creditor proof, all under Florida law. You can check the law of the state where you live, or you could save the trouble and just move to Florida. Also, you could have an automobile. You could buy it with a 60-month loan, so it never has equity, and then the creditor would have to pay the loan to get the car, or you could lease the car. Okay. Then, or if you had a girlfriend named Elise, you could lease the car. The living trust does nothing to avoid creditors, but doesn't hurt. The professional practice corporation has to be owned by the individual and is a sitting duck. It has accounts receivable, furniture, and equipment, and a phone number. So what are you going to do there? Well, owe a lot of money to a bank, don't keep a lot of extra money in the professional corporation, factor your accounts receivable to a related factoring company so you don't have any accounts receivable. Understand that if there's a judgment against the practice, the realistic worst case scenario is that the professional files a Chapter 7 bankruptcy and has the professional corporation sell its assets to a new company, to the highest bidder. Guess who the highest bidder is going to be? That's going to be the doctor's wife or something like that. Buy the stuff and start new. That's really the only way to do it, because once you have a judgment against a corporation, unless you do what's called a 363 bankruptcy sale, if you move the operations of the company to another company with generally the same ownership, practice, identity, and customers, then the judgment will follow. So the only way out of that is a bankruptcy sale. So we do like clients to have money owed to them or others by their professional corporation. And there's something you can do, which is a lot of fun, and that's called equity stripping. Now, you have to be clothed to engage in equity stripping, and we have slides on it. Perhaps there's a building with a mortgage on it, cross-collateralized with the professional practice assets. So this client may set up a gifting trust for his children, nephews, or nieces, which might own 3% of an LLC or a limited partnership to give charging order protection. Now, you may live in a state like Colorado or California that does not recognize charging order protection. There was a couple of years ago a decision by the Iowa Supreme Court, and they are one of the 51 most respected Supreme Courts in the United States. And they said that a person from Florida who was being sued could use Iowa charging order law to keep the creditor out of the LLC. So if you live in a non-LLC charging order state, you may still want to try a Florida LLC or Wyoming or Delaware to get that charging order. It may apply. There's only been one decision. There may be 50 more. I will keep you posted. Another alternative would be for this person to set up a Nevada asset protection trust. Now, Alaska, Nevada, Delaware, South Dakota, all pretty close in law. Maybe it's based on who you know. Maybe it's based on where you like to visit. If you like to ski, then you might want a South Dakota trust company. Or if you like to gamble, or you like entertainment and food, then you may want a trust company that's right near the strip, which has nothing to do with equity stripping. But in any event, I could form an asset protection trust and have a trustee in the jurisdiction hold assets, or perhaps hold a 99% non-voting member interest in a real estate LLC, while the gift trust owns 1%. So now if a judge says, hey, the 99% asset protection trust is a bunch of hooey, like Huey Lewis in the News, the judges didn't like him. But then if the judge does that, there's still going to be charging order protection. Now, an offshore asset protection trust will be much more likely to prevent creditor invasion if it's established well in advance of a problem, but much more expensive and cumbersome. So a Nevada asset protection trust may suffice. And if it's going to own S corporation stock, then you would have to put that under the domestic asset protection trust, not under the foreign asset protection trust. So that's just a little glimpse at the creditor protection aspects. One thing we want to ask our clients is, do you plan to inherit? And if you do plan to inherit, would you like to establish an inheritance trust so that your inheritance will be to you as trustee of a trust? You'll receive what you reasonably need for health, education, maintenance, and support. You can direct how it goes when you die, and your creditors cannot reach it, and it'll never be subject to estate tax. Would you like one of those? And then for you planners, my suggestion is, if it's not easy to get the parent's lawyer to set up the right document, you draft the inheritance trust for your client, the child. The child puts $10 in it on behalf of the parents, and then you simply send a copy of the trust to the parent's lawyer and say, please amend your client's will or trust to provide that my client's share will go into this inheritance trust. And that can work very well. Okay. What I also have for you here is some definitions that you can read through at your own pace. Automobile liability. When you are working on an estate plan, you should definitely ask, what cars do you drive? What cars do you own? And who drives your car? And then you should say, stop letting anyone else drive your car. Well, what about our teenage children? Well, put their car in your mother-in-law's name or your father-in-law's name, the one who has no assets, and then transfer it to the child when the child is 18. So we just want to be very careful on the car liability. I represent a lot of physicians who get sued for a lot of things, but a third of the time it's a car accident. It's not even the malpractice that you would have thought it was. An amazing book, one of the best books ever written, in the opinion of the best books ever written rating society, Dale Carnegie's book, How to Stop Worrying and Start Living. It is a fantastic book. It should be read by anyone who is a member of the human race because it has so many really good techniques about handling worry. And by the way, Saturday at 11, I'm going to be giving a webinar with one of my best friends and someone who's been an important mentor to me, Professor Srikumar Rao. So let me know if you're interested in signing up for that. It's free and worth every penny of it. And you've got my email address here at the bottom left-hand side. Obviously, I'm just scratching the surface here, but we should talk about the attorney-client privilege. What a client says to a lawyer in the course of legal representation cannot be discovered by outsiders. But there is an exception to the attorney-client privilege for discussions of helping a client commit a crime or helping a client commit fraud. And it is called the crime fraud exception to the attorney-client privilege. Now, I'm in Florida, and my duty to a client who is a debtor is to explain to them how to avoid paying their creditor, if that's what they hired me to do. But under the crime fraud exception, if I do that, then it is possible that a judge will be able to pry open my attorney-client communications. So this crime fraud exception, which was applied by the U.S. Supreme Court without Diana Ross, but nevertheless, the U.S. Supreme Court, she wasn't there that day, they said that if you make a transfer for the purpose of avoiding creditors, even though you're not committing fraud and it's not a crime, that the crime fraud exception may apply in bankruptcy court. And then that's been applied in a New York court. So we could see that coming. All right, I'm going to clear the deck now of the PowerPoints if I can. And there you can go to the Kettering Health Foundation website. You can Google Kettering Health, Gassman or Hesh or something like that. And you can sign up for this 7-hour continuing education credit. And you can have an autographed picture of Jonathan Blottmacher, Clary Red, or Jerry Hesh, 8.5 by 11. Judy, loved seeing you. Thanks for attending. Just let me know and I'll order those up. Now I want to show you the software. It's coming along very well, and I'm open to having beta users, and I'm going to give a free 1-year subscription to this software to anyone who signs up for the
Kettering program in the next 4 metric days. So this is Thursday, Friday, Saturday, Sunday. That's what you call 4 metric days. Give you a quick tour here. On the left-hand side, I have Bob's sample, and I can click his age up and down, and I can tell the computer how much of his lifetime exemption has been used. And then he can have a lovely spouse who also has an age and a date of death. And then I can decide whether there will be a portability allowance. I can decide if the exemption is coming down to 1/2 in 2026. I can set a value for their house, and I can set a growth rate for the house. I can set a value for their investment assets, and I can set a growth rate, a tax rate, and an investment cost. I can ask for the maximum amount that can be placed in a credit shelter trust under the scenarios. I can set up a trust for their children that would receive annual gifts based upon $17,000 per spouse per child. I can also allow a gifting of discounted LLC interests. I can set up life insurance scenarios with and without life insurance trusts. And I can set up an installment sale, and it's very easy to toggle a 10% down payment of $996,000 into a trust, put $15 million into a LLC, sell a 99% non-voting member interest at a 35% discount for $9,961,000 for a 4% interest rate note, payable interest only for 20 years, and pay an annual guarantee fee on that note of $5,000 a year for 10 years to the gift trust. And what happens if these people don't plan? Well, they are going to pay an estate tax of $9 million without planning. $20 million goes to the kids. With a credit shelter trust, they'll pay an $8 million estate tax. With discounted gifting, you see that they have, whoops, what happened? Discounted gifting, stop that. Go back to trust logistics. Okay, got too small. I guess it is April 20th, so people are getting small today. All right, so I'll move this to the left. Now you see the whole view. By the way, this works on an iPad, it works on your phone, it's web-based, you don't have to put the exact name of your clients into it, and it also works on an Apple product. Not a Pear, but Apple. Okay, so there's discounted gifting, and there is, if you do the installment sale, the tax goes down, as you can see, to $1.6 million, which means I should have done more installment sale. So now I can go back to the installment sale option, pull that out, and increase my installment sale to where the tax goes to 0. I can also, if it's possible to go to 0. Okay, I can also now look at this as a timeline. So this is where the red is the tax, the amount of the tax based upon the year that they die. Or with the bypass trust, here you see the bypass trust. All right, now I can generate a client letter. To do that, I click the button, believe it or not, that is called Generate Client Letter. And then it asks me what scenarios I want to show the client. I could select all the scenarios, or I could click off the life insurance. I can click off the discounted gifting. Do I want to show the timelines? Sure. Do I want to show more details? Not this time. Click Client Letter. And now, as you see, it's 4% done with the client letter. There's actually a secretary in the Bahamas who is typing this client letter, but he is a very fast typist. The letter is almost done. Give it just another minute or two. You have to be patient. Okay, the letter's done. Where's the letter? There's the letter. Open the letter. Enable editing. It's a Word document. And the letter summarizes all the information I just gave and explains how the system works and shows each step, both from the diagram standpoint and from this standpoint. And if you wanted other things in the letter, you could type it in, and what you type in will go at the bottom of this first page. So that is the Estate View first module. The second module of Estate View is the installment sale calculator, which I will not cover very much, other than to tell you that it can be a very useful tool for a single person to decide how an installment sale is going to work for them. And the installment sale, once you set up the installment sale information, which includes their asset information, you click Save Results to Excel, and then you have an exportable Excel spreadsheet, which is somewhere on my computer, but I don't know where it went, so I can't tell you. And then you can export that to the client's file and work with them to show this spreadsheet in Excel with whatever other information you would like to do. And if you want to know what the applicable federal rate is, you click there, takes you to the applicable federal rate. So, in summary, I hope that you will continue to consider signing up for the Kettering Health Foundation Trust Tax and Planning Strategies Seminar. If you sign up before the end of the day on Sunday, that's midnight Eastern Standard Time, send me an email. You will get a free year subscription and 2 free books. Any and all questions, comments, and suggestions that you may have for the Kettering program, our software, or anything else whatsoever, we will be glad to provide to you. Teresa, thank you very much for your compliment. We do not know what the subscription will cost for the software after the first year. We are working with the Lineberg people who are helping us to develop it. I'm guessing it'll probably be $395 or something like that. John, can we get the slides? Yep, we will definitely get you the slides. All right, well, thank you very much for attending this presentation.
And we'll see you at Kettering, if you show up. Thank you very much. And we're sorry about the quality of this program. Bye.
Okay, bye. Thanks a lot. I don't really appreciate your criticism.
Tough luck.